PepsiCo came into India and wanted to commercialize or start selling their Mountain Dew products, which is basically sodas, in 2003, they realized that there was already an Indian entity which was selling water under the mark Mountain Dew. There was an 18-year legal battle between these two entities, MagFast and PepsiCo. And finally, and this case went all the way to the Supreme Court up to, and then came back to the lower courts. And MagFast didn't have any trademark registration for Mountain Dew for packaged drinking water. But basically in 2022, after 18 years, PepsiCo succeeded against MagFast. And even though their use in India started much after Mountain Dew's use, MagFast's use of Mountain Dew in India. How this would have turned or may have changed if Mountain Dew had actually gotten registration, had maintained better records, is is something that we'll never know, because unfortunately that was not the case in their favor right now in this instance. So while in India, trademark law does recognize reputation of brands or trademarks in other parts of the world, because they sometimes transcend boundaries and can become well known in India, even if they don't have an Indian presence or don't yet sell in India. And combined with the fact that today there is no, the old ways of doing commerce and business have gone out of the window, and we are looking at online commerce. So there's a blurring of geographical boundaries when it comes to sale of goods. This makes it all the more important to understand and be aware of IP rights and specifically trademarks. And there cannot therefore be a more apt time to discuss today's topic, which is trademark insights and why MSMEs can't afford to miss out. And given when you combine this with the fact that MSMEs are now acknowledged as one of the pivotal or important growth engines of the Indian economy, if they prosper, so will India's economy. And in this ecosystem, IPRs form a very vital cog in the growth of MSMEs. One of the things that there's a lot of confusion around is the lack of clarity on what is IPR. Simply put, IPR is actually the intangible right in the output of creativity or innovation, right? But it's important also to understand that there are different categories or types of IP or IPR. The first one is, I'll just quickly go through these various ones before I come to today's most relevant topic, which is trademark. You would have heard of patents. Patent is a very commonly used term, often confused with trademarks, copyright, etc. But what is patent? Patent is an exclusive right which is granted for an innovation, and it can be a product or a process that is a new way of doing something, and it offers a technical solution to a problem. And what does patent protect? It means that the invention, which is that process or a new process or that product, a new product, cannot be commercially made, used, distributed, or sold without the patent owner's consent. Patent itself needs to be registered to get that protection, and the protection is granted for a period of 20 years. The next is copyrights. Copyright is actually a term which describes a right given to authors and creators of literary, artistic, musical works, photographs, and even copyright software code. And it can be a part of films, music compositions, paintings, drawings, sculptures, maps, technical drawings. And copyright is basically a right that given to the author or the owner to prevent others from copying or translating the work either in whole or in part. Copyright subsists in any work automatically upon its creation. It doesn't need to be registered. However, registering it gives you a immediate evidentiary right to show when it was created and the fact that you are the owner. So that is copyright, and therefore copyright covers the form or the form of expression. Patent actually covers a product or an idea. Third is something called industrial design, which is basically the patterns or ornamentation or shapes or colors and lines that are applied to any article which is manufactured in through an industrial process. And the what is protected here is the what the eye sees basically. And it's the protect again, design is protected only by virtue of registration, and it is initially for 10 years the protection, and then it can be renewed for a further 5-year period. If you don't register design, you will not be able to protect it unless it falls under copyright also. Without registration, then you may be able to get some remedies if someone copies. Fourth is an interesting one. This is called trade secrets, and it's basically means confidential business processes and information that gives an enterprise a competitive edge. And typically, trade secrets are guarded, protected by the enterprise, and very few people, and only those who absolutely need to know it, will be privy to this trade secret. It is never disclosed, because the moment you disclose it, it stops being a trade secret and loses the protection that it could get. Obviously, trade secrets, there is no registration because it is protected by virtue of the enterprise treating it as a trade secret. And then we have geographical indications. A very good example of geographical indications is Kolhapuri chappals. Basically, what geographical indication registration does is that it only people who are only manufacturing of products from that particular geography can give itself that name. So like I said, if the chappal is manufactured, if a Kolhapuri chappal, so to speak, is manufactured in Delhi, it cannot be called a Kolhapuri chappal. It basically protects a community of people who belong to that region and who manufacture that particular product from that region. Champagne can only be manufactured in that particular valley of France. Kulu shawls, Chanderi saris, these are all examples of registered geographical indications. There is some limited remedies available if geographical indications aren't registered, but registration obviously gives a much better protection. There are also other laws that protect things like utility models, new plant varieties, semiconductor layouts. And there you can get protection for these specific type of technology or products under these acts. And last but not the least, we come to trademarks. What is a trademark? It is basically a distinctive sign that helps identify certain goods or services as those produced by a specific person or enterprise. And trademarks can be, they can be words, they can be logos, they can be slogans, could be shape of products, could be sounds, could be any of these in color combination. So just to give you an example, Nike is a word, and that itself can be a trademark. The swoosh sign that you can see now on the screen is a logo that is also a trademark, and the logo of Nike, which is just do it, can also be the slogan, sorry, can also be a trademark. So, and I also mentioned that shape of goods can be protected under trademark. They can also be protected under design, but interestingly also under trademark. And one of the most famous examples is the Coca-Cola bottle shape, which has been protected as a trademark. And sounds have started now getting protection as sound marks have started getting protection as trademarks. One of the earliest was the Yahoo Yodel, which got protection as a sound mark. And more recently in India, also apart from other countries, Netflix, the opening bars when you put on Netflix, that sound has also got trademark registration. So what happens, what does trademark protection do? Trademark basically provides protection to the owner of the mark by ensuring that The owner has the right to use it exclusively to the exclusion of others, and also that they can, authorize or grant rights to others to use it for certain consideration or payment. Um, while trademark need not necessarily be registered to get certain protection, registered trademarks do get better protection, and I will deal with that in the later part of this session. Once registered, then trademarks get an initial 10-year protection and can be renewed for further 10-year periods in perpetuity. And one of the best examples, now that I've taken you through all the various types of IPs, one of the best examples of almost every type of IPs existing in one product is this Coca-Cola bottle. The Coca-Cola bottle cap can be protected by virtue of patent because it solves a problem. It is an industrial process through which a product is made. It was made to stop the fizz from emanating, and there was a certain technology behind it, so that the bottle stopper can be patented. The shape of the bottle can be protected by way of design as well as by way of trademark. The logo on the Coca-Cola bottle is protected by trademark. The recipe or the formula of the liquid inside the Coca-Cola bottle is actually held as a trade secret. It's one of the most famous trade secrets. Nobody knows except the very few people who need to know how that liquid is produced. And to extend it further, the advertisements where the Coca-Cola bottle is featured would various aspects of those advertisements, whether print or audio or video, have different aspects that can be protected by copyright. Uh, Now that I've kind of taken you through the topography of IPR in general and the various categories, I'd like to focus more on today's relevant topic, which is trademarks. Why is a trademark important? Now, trademark is also called as in common parlance, we call it as the brand. And trademark could be your company's trading name, or it could be, for example, a Bajaj is a trademark and it's also that entity's trading name. Or it could be a sub product, a brand name within your enterprise's umbrella. For example, Surf, which is a brand of Hindustan Unilever. Um, but why is a brand so important? What we have to realize is today there are new ventures emerging every day. We live in an uber competitive environment, and how do you therefore how do you as an enterprise carve out a or mark your presence in the market? And this can be done through trademarks or brands, because these trademarks or brands represent your business's value, reputation, quality of products, and therefore your market presence. So, and protecting therefore your brand or trademark in this competitive environment becomes extremely crucial, so that you can, especially for MSMEs who are trying to carve out a niche in the market. When we see a half-eaten Apple symbol, we immediately associate it with iPhone, iPad, Mac products. Similarly, if you see a three-pointed star within a circle, we know that I think even a child will recognize it as a Mercedes-Benz. If you hear the tudum sound with a red N on your TV screen, you know that it's Netflix. And when we see the word Tata anywhere, we immediately associate it with a trusted business group and high quality of products and services from India. So, I mean, this just goes to show that association of a brand with the enterprise and the products and services of that enterprise creates a recall value in a consumer's mind that would otherwise only be possible if you through very expensive marketing and advertising campaigns. And the goodwill that is created by a strong brand, which is immediately associated with the products of that particular enterprise, also carries a certain economic value for the enterprise, because this goodwill and the trademark are actually intangible assets of an enterprise, and their commercial value can be realized actually by the enterprise through licensing, through franchising, or even sale of the mark. And there have also been instances where this intangible asset, like a trademark, has actually been used as collateral for accessing loans. One famous example is Kingfisher. The brand, the logo, the famous Kingfisher logo mark was actually provided as collateral for some of the Kingfisher marks. Of course, it's a different story that haven't been any buyers for that particular brand at this point of time, because many other factors that surround that particular story. So when we say that it's an intangible asset, just like an enterprise would protect any other asset, it is important to also protect this intangible asset. But what happens if an enterprise has low awareness, or in some instances they don't focus much on on their trademarks or their brand and how to protect their brand? Basically, what the fallout of this would be that there is no comprehensive trademark strategy that the enterprise will have. And instead they will be scrambling when there is a crisis and firefighting. But and why would that be a problem? Because often, if you don't have a trademark strategy, then you may not realize your full potential, your enterprise's full potential, and lose your edge in the market. And what do we mean by trademark strategy? Trademark strategy is various things. What mark should you apply for or adopt? What, can you adopt it? Should you adopt it? Which markets should you be looking at for that particular brand protection? Do you register it? Do you not register it? And if yes, in what geographies? And for what goods? How do you stop competing, others from copying your mark, or how do you deal with competing marks? All these are critical decisions which form part of the and can lead to an effective trademark strategy for any enterprise. And when we talk about trademark strategy, it involves simple things like doing research, understanding if there are other products in the mark before you adopt a brand, understanding from various trademark databases if there is something that others have already applied for. This will help you avoid conflicts and legal disputes. And also, if you keep, you can also minimize the risk of infringing others' marks then, if you do this kind of comprehensive search and research. Trademark strategy also involves proactive trademark registration with, in relevant markets, which again would be something you would determine as part of your trademark strategy. Because once you register, there is a certain, exclusive right given to you, and there is a legal presumption of ownership, which helps you then ward off competing marks. And also, the moment you have a registered mark, there is also an added credibility in the in the eyes of consumers as well as others who may be looking to engage with your enterprise. And of course, the problem with trademark strategies, sometimes even big enterprises fail to put in place a good trademark strategy. For instance, in 2007, when iPad was launched by Apple Inc. in China, they faced significant challenges because there was another entity in China which had already registered the iPad trademark. And that led to Apple having to settle the matter with that Chinese entity by paying millions of dollars. And maybe if Apple had, kind of strategized early enough to apply for and get registration even before they launched the product, the outcome might have been very different, with not that much money having to be paid paid by Apple Inc. And more recently in India, Wow Momos, which is again a mark that we all are familiar with because we see their boards everywhere, they've had an uphill task in trying to stop others who are in a similar industry as them from using the word wow. Because courts have repeatedly held in many of the cases that where they're trying to get remedies, that wow is a common laudatory term, and you can't stop others from using it. So again, whether they whether that choice of the mark, could it have been different? There are many questions around that also. So it just goes to show that a trademark strategy is of vital importance. The other thing of low awareness of trademarks is that there is an inability to prevent others from copying. Because you don't know how, you don't know what your rights are, you don't know what is the logical next step to take. And also there is no vigilance, there is, because one of the important things is that if it is an asset, you also are safeguarding it. And you have to be vigilant, monitor the markets, enforce your trademark rights to prevent others from infringing or copying, and therefore preserve your brand's integrity as well. And it may involve having to send cease and desist letters or pursuing legal action. But if you are not aware of trademarks and all these possible options, then you will never be able to take the right route to prevent others from copying. And if you don't prevent others from copying, your mark gets diluted. Your position in the market is getting diluted. Therefore, low awareness is a very, very, it becomes a very risky thing, because then MSMEs lose out on a brand that they may have actually created with a lot of effort. Uh, and here I would actually like to talk about one very interesting case. If you see on your screen, I've put up these two. One is a Burger King logo on the right side. On the left side, you have a Burger King board. So there is a Burger King in Pune, which started, as early as in the 1990s, and it was a local eatery in Pune, very popular. Burger King USA it was going to enter the Indian market, but much before that, Burger King filed for a trademark registration for their mark in a very different category, not related to, for very different products, not related to their core business. So when they were going to enter the Indian market and they were looking at what, the Indian market, they realized that there was this very popular eatery in Pune which had the name Burger King. Now the Pune Burger King had filed an application for registration of their trademark, and that's when Burger King woke up to the fact that this mark was already in use in India. And they tried to stop Pune Burger King from using their mark and preventing the registration as well, because based on their trans-border reputation. But they failed in their challenge because they were unable to show, their reputation prior to their entry into India, and they had not filed in the important CAT class, the class that was important for their core business. So this again goes to show that even big enterprises somehow mess up on their IPR strategy, which is why IPR strategy is critical for protecting an enterprise's brand. The third thing is that if you have low awareness, you also don't know how to exploit the value of your brand or your trademark, uh, because there are many ways to realize the commercial value of your brand, and you will miss out on these if you have low awareness about trademark and what it means. So for example, you could use the brand, like I said, for raising funds. You can, as a collateral, you can assign it and make money off that assignment. You can license it to people. So there's many ways, and those you would be able to maximize the monetary value of your brand only if you have awareness of whether you have a trademark of value and how you can exploit it. There's a very interesting story of one Mr. Matlani from Indore. I've put this really bad quality logo here of Jet. Unfortunately, this was the only one that I could lay my hands on. So Mr. Matlani was a bank clerk, and he was also an entrepreneur of sorts, always looking for business opportunities. When he was in Malaysia, when he was visiting Malaysia in 1985, he came across mosquito repellent mats, and he realized that that would be a fantastic product for the Indian market. When he came back to India after his visit, he invented a small machine for manufacturing the mats. Then he did R&D, and he came up with the formula for the mats. And Then he said that has to have a good name, and he came up with the name Jet. He applied for the Jet trademark for the name Jet, the mark, which I've actually put up here, and he got trademark registration. The product became a huge hit. I think people who were who were around in the 90s will remember that everybody would have used those little machines with the little mats, and Jet was the brand to go to. It became such a huge success, so much so that when Godrej, the big company, wanted to enter the mosquito repellent market, uh, they were looking around to see how can they enter it with a big bang, and they decided that this Jet trademark would give them the visibility that was needed. They paid a whopping 300 million rupees to Mr. Matlani to acquire the mark and launch their own product under this Jet mark. Just goes to show that if Mr. Matlani had not been vigilant and protected his mark through registration, he may never have got that 300 million rupees. He had the awareness and he was able to milk the value of his intangible asset. Okay, so now that I've spoken at length about why trademarks, the awareness, what benefits it can lead to, I would also like to talk about these two symbols that you see on your screen. Often you would have seen the name with a symbol on the right-hand side, one or the other. On the left, on one side, we have the TM symbol, which basically stands for an unregistered trademark. So it could also be where somebody's made an application for registration and not yet received it, or it could be a mark that somebody's not applied for, but they are claiming that it is their trademark. And the other one is the R within a circle, which symbolizes a registered trademark. Now, I had mentioned earlier when we were just discussing different types of IPR that unregistered trademarks also have certain amount of protection in India. It is not necessarily true that if they are not registered, then they have zero protection. So what if you have not registered your trademark and someone else starts using a similar mark for similar goods as yours? Does that mean that you have no remedy in law? Fortunately not, at least in India, because trademarks that are unregistered can still pursue the remedy of passing off in civil courts, and there could also be certain criminal remedies that are available. However, what happens in the case of unregistered trademarks is that the entire burden of proof is on on the person who wants the passing of remedy to show that their mark is has got it is there owned by them, and that there is certain goodwill and reputation that associated with that mark, that the other party who's passing off their goods under that mark is actually misrepresenting to the public, which is leading to confusion as to whose goods are being sold and or services are being provided, and also that damage has been suffered by the party trying to get the remedy of passing off. So these multiple tests have to be satisfied with very high level of evidence to satisfy a court of law in order to get your protection of passing off. And the burden for showing all this falls squarely on the person who owns or claims to own that unregistered trademark. And it's not an easy task, let me tell you, to meet that strict proof standards. Many big companies have failed to establish these facts, and their passing off actions have failed. One such instance is of Toyota, the famous Japanese car company. They when they wanted to enter the Indian market with their Prius brand, they realized that there was already an Indian auto part company called Prius Auto, and Toyota tried to proceed on the basis of passing off against Prius Auto, but they could not do so because while Toyota itself was well known in India, Prius was not well known in India, and they therefore could not show that the Prius mark had any goodwill in India prior to 2001, which was the relevant cutoff period. And so they failed to prevent Prius Auto, which was an Indian entity, from using their mark. Does that mean that odds are better for a registered trademark? Yes, that it does, because when you have a registered trademark, why, I mean, like I said, if you have unregistered trademark, you do have protection, then why would you go for registration? Simply because the advantages shift to the owner of the registered, or the proprietor of the registered trademark. By virtue of registration, what happens is you get the exclusive right to use the trademark in respect of the goods or services for which you have applied, to the exclusion of everybody else. However, one thing, there are some exceptions to this. A prior user may get better, may also be allowed to use it, but again, the burden will be on the prior user to show that they have been using it extensively before you started using it. The second thing, the second advantage of just registered trademarks is that there is a legal remedy against third-party infringement, which is available automatically to registered trademarks, and you will not have to meet those stringent tests that unregistered trademarks have to meet for passing off. The burden is no longer on you to show anything. Your registration itself puts you at a stronger position, and it will be the other party against whom you are claiming infringement who will have to show various things to be able to get out of infringement. And registration is basically prima facie, evidentiary value, regardless of recognition, etc., that it is your mark and that you have the right to prevent others from using it. The third is increased credibility of the brand. Like as we saw in the jet mosquito repellent mat story, if you want to commercially exploit your brand, registration gives you the credibility with outsiders, banks, investors. Everybody looks at you as a professionally run enterprise that is protecting all your intangible assets as well. And now increasingly several online aggregator platforms, like Amazon, Flipkart, they also ask for trademark registration details or application details if you want to list your products under your brand name, under a particular brand name on their platform. The fourth benefit of registered trademarks is that you could then expand your business knowing that your mark is protected. One thing that I will get into in more detail in the next slide is that trademark registration is geography specific, but within India, for example, if you get registration, you can go to any state and your mark is protected and you can expand without worrying about it. Also, internationally, it's easier to get protection if you already have registered it in India. You can then expand in other markets and also try and protect it outside India. And most importantly, protection is for, like I said, it can be renewed in perpetuity, while the initial protection is for 10 years, and it's at a very low cost. So you have an asset which can exist forever. So those are the advantages of trademark. And but what we have to remember is that there is a process involved. It is not an instant, registration, and there is a process involved, which I will get to next. I've just put up a comparison of the advantages between or the features of registered versus unregistered trademarks. Just a snapshot of what I have just explained to you. Okay, so coming to the process of registration, what we have to, trademark registration is not a very expensive process, though it does take some amount of time, and an average between 2 to 3 years. And for MSMEs particularly, it's a very inexpensive process because the government has reduced fees, official fees or government fees payable for trademark applications for MSMEs. So, it is even though it takes some time, the cost involved may not be too much. So there's very little reason not to go for trademark registration. Now, one of the things we have to remember is that trademark, like I explained, it could be a logo, it could be it could be a word, a symbol, it could be a word, a sound. There are so many types of trademarks. It could be a coin term which has no dictionary meaning. So there are all kinds of trademarks, and what is protected when you apply for registration is the exact form in which you have uh, represented your trademark to the registry in your trademark application. That is what gets registration or protection. Protection is geography specific. So protection is only available in India if you apply in India. If you want to get protection in other countries, you will have to go through a similar process in other countries as well. And the protection, like I said, initially for 10 years, renewable for further 10-year slots in perpetuity. Another important thing to remember is that trademark registration or protection is only for the goods or services that you actually apply for. You will have to give a description, and by law there are 45 classes of goods and services. So goods and services have been split into 45 classes, and most goods and services fall within one class or the other, and you have to choose the relevant class and give the exact description of goods or services you want to protect for that particular mark, and your protection is actually restricted to that. uh, I mean, like I mentioned, trademark registration is country specific. So, where do you apply for trademark registration? Obviously, in the case of MSMEs, India is a very vital location. So, you would by default apply in India. But it doesn't mean that India is the only relevant country. You would, look at other markets. You'd look at your budget, because the moment you go to other countries, the cost becomes more, and then you may have to evaluate when and where else you want to register. In India itself, trademark applications are made to the registrar of trademarks. There are offices in Mumbai, Kolkata, Chennai, Ahmedabad, and Delhi. Your principal place of business decides which is the relevant office. Having said that, now everything is online, and therefore it's a very simple process. Even if the trademark office is not in your state or in your city, everything can be done online. Next question is, when do you consider applying for registration? The law allows you to apply for registration of a trademark at any time, whether you've used it or you haven't used it. Those are actually decisions that you would take as part of your trademark strategy. If you haven't started using it, it's called proposed to be used basis. You can apply even then. If you have started using it, then you can claim a date of use. And in that case, you will have to submit evidence along with your application to to establish the date of use you have claimed. Now let's look at what are the steps that a trademark application typically, or the registration process. First thing would be to do a search. This is not a mandatory step, but as I had mentioned, as part of the trademark strategy, search is a great thing to do because it tells you if there are others in the similar industry or for the similar goods and services who have already applied for or got registration. Search can be done on the trademark office database. I have put up a URL on this slide, which you can see right on top. That in that URL you will be able to do a search. Anybody can do a search and you can find other marks that may be registered or applied for, which are similar to what the mark you're interested in. Once you've and search will also tell you if anybody else has already adopted the mark. So you may get a chance to change your mark if you've not started using it, or you may decide the kind of evidence you want to show if you want to apply for it because you've already started using it. So there are decisions you can take based on the results of the search. So search is an important step. The next would be to actually draft and file the application. As I mentioned, it's an online process also, but you can also do it physically. The fees is a little less if you do it online, and for MSMEs there is of course a bigger discount available. Again, that URL that I've put up there is the URL to be used for making the application. And the application is a standard form, and it has various rows against which you have to fill in the details, and you have to pay the fees, which at this point is 4,500 rupees per mark per class for MSMEs who have MSME registration, their Udyam certificates in place. And there are a couple of other things that need to be submitted along with the application and the fees. If, like I explained, if you're claiming a date of use, you have to submit evidence along with an affidavit, which is on stamp paper. You can also use third-party, trademark agents and attorneys to file the application for you. And if you do that, you will have to submit a power of attorney has to be given to them, and that also is normally submitted as part of the application package. Once you file your application, the registry examines your application and will raise both procedural and other substantive objections. It may be that there are no objections, but if there are objections, procedural objections would be if you have claimed reduced fee as an MSME, but you haven't submitted your MSME Udyam certificate, or your POA has not been submitted if it was filed by somebody else on your behalf. Those are all procedural objections, and substantive objections that could be raised by the registry after examination relate to the mark and the services itself. Typical objections would be that other marks are already there on their record, or that the mark is not distinctive, it's got very common words, or it's describing the services, or it is common laudatory terms. Those are the typical objections. These will have to be responded to in writing within 1 month usually. And after the response to this examination objections are filed by you, the registry will then either be satisfied with the responses, or they will call for a hearing. At the end of the hearing, they will be either satisfied with your submissions or refuse your mark. If there is refusal, then of course there are remedies like appeals and reviews which are possible, which I'm not going into today. But if your mark is accepted, then it is published in what is called the Trademark Journal. Once it is published, and that is the publication stage, once it is published, there is a 4-month period during which anybody can file oppositions to your trademark. If their opposition is filed, usually it is filed by people who have similar marks, then there is an entire different process through which one has to go through before you get a decision on whether your mark is allowed or not. If there is no opposition, then the mark, within that 4-month period, then the mark proceeds to registration, and you will be issued a registration certificate, and the registration is valid for 10 years, after which it can be renewed. So from our experience, as I explained earlier also, the entire process, if there is no opposition, it takes anywhere between 24 to 36 months. But if there is a third party opposition, then it does extend the period. And at this point, it's difficult to say how long it will take for that to happen. This is in a snapshot the process or the steps for trademark registration. You can apply for it yourself. You don't need to engage anybody else, but probably at the examination stage, you may need more specific expert legal help. The other thing that I would also like to draw your attention is there are several MSME focused schemes that Government of India as well as state governments have come up with. There is the MSME Innovation Scheme of the Government of India, which is encouraging MSMEs to apply for IP protection. There is part of it is also the lower official fees that has been extended for MSMEs for trademark registration. The Government of India is also, has a list of trademark facilitators who have fixed government costs at which they will provide you, legal help in your trademark process. And there are several state-level schemes for MSMEs in Tamil Nadu, Goa, Puducherry, Rajasthan, where you could claim refunds or reimbursements for the money you've spent on creation of IP. So these are all MSME-focused government schemes. So the importance clearly of MSMEs in the economic ecosystem and vis-a-vis IPR is clearly well recognized. And as I've explained, it's cost effective. It gives you several advantages. There is a push to make MSMEs, create and protect their IP. And there are so many advantages of creating this valuable intangible asset which you can commercialize and commercially exploit, that there is very little reason not to go ahead with trademark registration, because that will make you enjoy the fruits of your efforts, where you bring quality goods under that mark and quality services to the market. I think with that, I would like to close today's my part of today's session, and I would like to hand it back to Shilpa.
Yes, yes, yes. Yeah, and thanks. I think Nirupama, this was quite a detailed, process, step-by-step process on how MSMEs can go for trademarks, the costs involved in that, and the plus and minuses, what they less of minuses, but of course the positive sides that they need to see while going for trademarks. And I think all the examples that were also used, to really highlight that, what happens when you want to do something but you have not acted on time. So I think all those were quite useful, and I think all our audience MSMEs would have, I bet they already know, but this would have really emphasized why they need to go for trademark registration and IP protection if they have not already. So I think I'll once again urge our all audiences, if you have any questions, if you have any thing, you can always write to us. We will be happy to get back to you with our responses. And essentially, like I said, we are starting this webinar series because we realize there are so many aspects where MSMEs do need support, they do need hand holding, and awareness was one of the I think areas we have realized. And that's why this early awareness, like I think Nirupama said, we are trying this to build early awareness on trademarks so that we can help MSMEs to strategize their operations, their growth better. And overall, when we look at MSMEs, so we have been, like I said, working with state governments, reaching out to MSMEs, trying to understand what what the on ground problems are. And overall, what we think is, what MSMEs really need at this stage is they need access to finance, which obviously everyone knows. But it's not just finance, but also the right information. So our webinars are one of the source for that. Then they also need access to experts. Again, we have like our partners like Nirupama from Thomas and Krishnaswamy Associates. So we have our experts through whom whatever the guidance and mentorship our MSMEs are looking at, they can get that as well. And finally, access to markets, because once you want to grow, finding out which other markets are relevant for me, from where should I buy, to whom should I sell, all of this information, put together in a easy to understand and follow way is what our aspiration is, and that's what our platform Iris Peridot does. So if you have, I'm sure who are watching us live on MSME TV of Peridot, they already have Peridot. But those who have not, I would request, please go to Play Store, App Store, download the app. So this will not only give you access to information, but we are also coming up with a lot of features that can help MSMEs to be digitally empowered. So be it generating your invoices or even e-invoicing if you are covered under the mandate, getting access to finance. So we are now soon going to open up our the digital lending channel. So if you are looking for getting access to finance, so these are some of the areas that we are of course trying to slowly and steadily implement for MSMEs. We are always here open for any ideas, any feedback that come from MSMEs where they think we could help them to perform better, because I think that is our overall objective. We want to do things which can help strengthen the backbone of our economy, that is the MSME sector. So I think with this we can end the webinar for today. Like I said, if you have any questions, you can always write to us at hello@irismsme.com for any legal and the trademark related specific things if you are looking at, or even assistance on how to go for applying for trademark. We have our partners. You can also reach out to them directly, and follow us on our social media handles to be updated for which next webinar we are coming up with, which next event we are coming up with, so that we can share the knowledge, get you in touch with the experts. Okay. So with that, we end the session for today. Thank you, Nirupama, so much for the insightful session, and we look forward to have another one with you, in the coming days again.
Same here. Thank you so much, Shilpa.
Yeah, thank you.